Good afternoon. It hasn't broken, has
I
it?
get myself properly dressed there. My lord, we'd reached what I might say is the critical point and the nub of the problem. I would hope that we could conclude that in 2008, share premium is treated as part of the capital of a Jersey company, along with the other components of the capital accounts, the nominal share capital accounts, the stated capital accounts of a par value company, and so on. And the choice that is then made by the Jersey legislature is to move away from the maintenance of capital principle, the whole basis of which is that you cannot pay a dividend of capital, to a solvency statement basis for the protection of creditors. And the question is, as I posed it, is does that decision alter the nature of the payment that's made when it then becomes possible to make a distribution out of capital accounts, both the share premium and the stated capital account of a no par value company, using the same mechanism as is available for paying dividends out of ordinary profits and earnings, whether realised or unrealised. And my simple answer is that it doesn't make any difference to the nature of what is paid. What is being paid out is received, as I say, I cannot see on what basis it can be said not to have been received as capital. It's been recorded and maintained in the company's accounts and its balance sheet as capital attributable, in Jersey's case, to each specific class of share in respect of which it was paid. And now that can be returned to shareholders using the ordinary mechanism of a dividend. Now, it's observable that virtually all authorities do not address this question because they're all dealing with cases in which the maintenance of capital provision is applied so that a dividend cannot be paid out of capital. So there's no question about whether or not the dividend is of a capital nature or not. All we can observe from what we know of the past is that at a time when dividends could be paid out of share premium by UK companies, UK resident companies, they were not taxed as income. That under the maintenance of capital.
Yes, sorry, you did mention that before, and you referred to Hill and Bates.
Yes.
Which obviously aren't tax cases. So
no.
Are you referring to a passing reference in those cases?
Indeed, I am. I think more than a passing reference. The whole point, they were trust cases, as you correctly say, my lady. And of course, the question was, did what was paid belong to the income or the capital beneficiaries? If you go to Bates, which is at page 372 of the authorities, you can see from the head note that the directors of a company owning and operating steam trawlers, having sold some of their vessels for sums largely exceeding the values at which they stood in the company's balance sheet, had carried the proceeds to a suspense account and afterwards distributed them as cash bonuses to its shareholders with a covering letter stating that such bonuses were capital payments not liable to income tax or super tax.
Yes, presumably at the time that followed from the approach of concentrating taxation, as it were, on the company's business. The approach you mentioned earlier, which never applied to foreign non-UK resident companies.
Madam, yeah, absolutely, yes.
So it's a consequence of the fact that the company in question would pay tax on, at the time, its revenue profits.
Indeed.
And these sorts of amounts
Yes.
would not have been caught by that tax charge.
Yes, because they were regarded as capital and therefore
So,
not,
yeah,
not
but
subject to.
my point is that
Yeah.
rather than it being a particular choice of, if you like, the income tax code as to whether something was of an income or capital
Yes.
nature, it followed from the taxation treatment of the entity, because at the time that's what dictated
Indeed.
tax treatment of the share.
And one, of course, one of the questions is that when the ITOIA then says that what you're going to tax is a dividend of a non-resident company, but not a dividend of a capital nature, are you entitled to look at if I say where it comes from, if you, I mean, of course, it's the source in the sense of the source of profits out of which it's paid, which is why, as you quite correctly say, in the context of a UK resident company, where they are effectively, in shorthand terms, transparent, you're looking through and saying, you know, did this come from a tax fund? No, it didn't come from a tax fund, and therefore it's not liable to tax in the hands of the shareholder.
Mm.
Okay, whereas in the case of a non-resident company, when I say the principle, the point is we don't know where this comes from because it's a non-resident company. You know, going back to the 18th, 19th century, you know, there's no sort of published accounts. It's not like Glencore these days, which has got sort of, even though it's incorporated in Jersey, operating in Switzerland, you know, and listed in London, you know, there's all manner of information available about it. That, you know, that might not exist in those days. So they say, well, because we don't know where this came from, therefore we're going to tax the shareholder in respect of what he gets. That's the sort of basic non-resident company approach. Okay, now, but as a general principle, that is why you look to how the foreign company law treats the amount, because that's what you want to know. You don't want to know how it got this money that it's paying back to its shareholders. You want to know, what does this represent that you've got from the company? Now, the only authority, so my lady, sorry, maybe I'm taking this too quickly, but my point was that so far as we look back at authorities, trust authorities, or even tax authorities to the extent that we have them, all we have is authorities which are effectively underpin them is the maintenance of capital. In other words, you can't pay a dividend out of share premium. So we don't have a relevant authority to look at. What we do know from past authorities is that in looking at whether or not what is of a capital nature or what is capital nature or not, is how is this dealt with under the foreign company law with which we're dealing? What is it that is being returned? Not how did it generate the profits to be able to pay it, which is the question in relation to a UK resident company, but what is it that's being returned?
So if I've understood this correctly, you very much do look at the prior case law to make the point that the local law, the law of the company in question, is the critical law to consider, as I understand it.
Absolutely.
But insofar as the previous case law appeared, possibly to the untutored eye, to turn on a test of whether the corpus of the asset remained intact, you would say that is no longer the critical test.
I would say it's no longer the determinative factor. Let me put it in those terms. As in my discussion with Lady Justice Appellant before the short adjournment, I recognise that, of course, what happens, if there is some impact on the corpus, that's a relevant factor to take into account in answering the question, is this of a capital nature? But at the same time, we're looking at a species of payment which is characterised as a dividend, and a dividend in the old maintenance of capital language doesn't ordinarily affect the corpus of the asset, because what was a share before the dividend remains the same share afterwards. Now, there is an exception to that, which I deal with in my skeleton argument, which is re Duff, which says that the company law, which says that share premium is part of the paid up capital, has the effect of attaching itself to the share, so that the nominal value of the share is not just the nominal par value, but it's the nominal par value plus the premium. Now that, of course, is an authority on trust law, but of course what it said was that what was treated for trust purposes before 1948 as income has become capital after 1948. Duff is again in the authorities.
Tab 23.
I'm grateful to my learned friend, tab 23,
yes,
which is on page 431.
It strikes me that Duff might be quite a helpful case to look at.
And this is considering the situation, again, obviously for trust purposes, and there is an issue as to what extent trust principles, can I say, determine the tax treatment. I will go on to say that of trusts obviously use many of the same principles, but trust law has never been determinative of the tax treatment. Witness the fact that for trust purposes, a dividend of share premium of a UK company, when it could be paid, was treated as income belonging to the income beneficiaries, but of course was not taxed on them because it was capital in nature. So in particular in the Court of Appeal, it's Lord Justice Jenkins in Duff at 434, page 43 of the authorities bundle onwards, where he explains that once share premium under the company law...
Sorry, you're using bundle references, are you?
My apologies. Yeah, it's page bundle reference 434 to 436. It is sideline. His point being, it goes on actually all the way to... it's a lengthy extract. Again, I won't read it, but it goes right on to 439, or even beyond, actually. Really to the end of his judgment on 440. But the essential point he's making is that once the relevant company law has said that this premium is to be treated as paid up share capital, a nominal share of, say, 1 shilling that has, a 10 shilling premium is to be regarded as a share of 11 shillings. And the repayment of the of part of the premium goes to the capital beneficiaries, not the income beneficiaries. As I say, that's for trust purposes, but it's recognising that the effect of the company law in that particular instance, which still applies a maintenance of capital principle, but nevertheless, as a matter of its company law, says share premium is part of the company's capital, that is recognised when the company comes to return part of its capital. And the question for us and for you, my lady, under the in this particular case, is that you've got a company law which up to 2008 treats share premium as capital for the reasons I've given you. Also, I do not see how up to 2008 it could be treated, share premium could have been treated anything other than as part of the company's capital. And then in 2008, the legislature says, we're not going to apply the maintenance of capital principle. We are going to have a solvency statement instead, because that's a better way of protecting creditors than the sort of rather artificial and uncertain means of just saying, well, you can't pay a dividend out of capital. And of course, a consequence of abandoning maintenance of capital, as the Jersey legislature recognised or did under the amendment in 2008, was to say that you can use the same mechanism for paying an ordinary dividend to return part of your capital accounts to shareholders. Now, does that change the nature of what the legislature has always recognised and is recorded as part of the capital of the company? I say it doesn't. The only authority in which this has arisen, this issue has arisen, is the case of First Nationwide, where the Revenue argued that the repayment by the Cayman Islands company of the share premium was a dividend of a capital nature and therefore was not within the scope of the stock lending rules as they then existed.
Well, just to be clear, it wasn't quite the same, wasn't exactly the same wording, was it? They're not looking at.
No, well, so the legislation, of course, in the issue in First Nationwide was stock lending legislation, and the question was whether or not it was a dividend within the meaning of that, which of course led to rather a lot of sort of complex and intricate argument about what's a dividend and what's not a dividend. Does a dividend have to be paid out of profits, and were these profits, etc., which doesn't really arise here because the Jersey experts were agreed that, you know, if the Jersey legislature had wanted to characterise this as profit, they'd have had to have said so, and they didn't. But leaving that point to one side, in First Nationwide, it was determined that the stock lending rules, when they referred to a dividend in that context, were referring to a species of income that was charged to tax under Schedule D, Case 5. So it was under although First Nationwide was argued after the tax law rewrite, of course it concerned the legislation before the tax law rewrite. So the issue was this dividend of share premium a income within Schedule D, Case 5? And there were two particular factors. I mean, obviously, the Revenue was saying that this was a dividend of a capital nature and was not the sort of thing encompassed. But of course, it had to face up to the fact that it was dealing with Schedule D, Case 5. So the shares were the possession, and the possession, so the Court of Appeal concluded, was the same after the dividend as it had been before, and therefore this was of an income character. And therefore it wasn't a dividend of a capital nature. Of course, being case 5, it didn't refer to dividend of a capital nature, it referred to income from the possession, being the shares. And the fact, and one of the particular things the Court of Appeal decided was that just because the capital rights attaching to the shares diminished each time a dividend was paid, that did not mean that the corpus of the share changed. In other words, the corpus of the share comprised its rights, which included dividends out of share premium of these particular amounts. And therefore, just paying those dividends out of share premium could not alter the nature of the possession that you had, because your possession effectively entitled you to those dividends. That was one thing. But the other major problem for the revenue in First Nationwide was what the Cayman Islands had done regarding share premium. Cayman Islands had removed it from the category of capital. In other words, under the Cayman Islands company law, the share premium was a profit, as it had been under the English law before 1948, and the only way it could be returned to shareholders was by way of a dividend, or obviously on a liquidation. It wasn't a species of payment that could be returned as capital under the Cayman Islands law. And the exception to that, we can see that in the authority, the exception to that was no par value shares. So if we go to the Court of Appeal decision in First Nationwide, which is at 642 in the bundle, it's section 34 of the Cayman Islands Act, I think. It was originally section 32, but is now section 34. Yes, it's at the bottom of page 649. And you see that section 34(1) says, where a company issues shares at a premium, whether for cash or otherwise, a sum equal to the aggregate amount of the value of the premiums on those shares shall be transferred to an account called the share premium account. And that's what it directed. So a share premium account under Cayman Islands law wasn't part of the capital of the company, wasn't treated under the Cayman Islands company law as part of the capital of the company. But then it goes on to say, where a company issues shares without a nominal or par value, the consideration shall be paid up share capital of the company. So it's making the very necessary qualification that if you're dealing with a no par value company, you need to specify that that is part of its share capital. But you don't need that specifically, that same specific direction under Jersey law, because it's clear that when a company issues shares at a premium, that premium enters the share premium account and is recorded as paid up share capital, because under Article 39(4) of the Jersey law, it is directed that the payment is treated as the share capital, and that is where it resides, and that is the quality and character that it has. And the distinction is, when I say the distinction is very simply illustrated. If you have capital profits or income capital profits, including share premiums such as you had in the Cayman Islands, the only way it can be returned to shareholders is by way of a distribution in the form of a dividend. But under Jersey law, you have share premium which is contributed and as I've shown you, enters the capital account of the company in just the same way as the stated capital of the no par value company. And so long as it resides in that account, it is recorded and treated as paid up share capital. Now, does it make any difference if Jersey says, for the protection of creditors, we're no longer going to continue to have the maintenance of capital provisions? That no longer applies Trevor and Whitworth. We're going to have a solvency statement. And as a consequence of that, it becomes possible to return capital, both share premium and stated capital account of a no par value company, by way of a payment that qualifies as a dividend. I say it doesn't make a heap of a difference to it. It's got nothing to do with it. They're changing the law because they're providing better protection for creditors. The reason why Trevor and Whitworth applies the maintenance of capital principle to share capital and statutorily it's extended to share premium is precisely because the character of that payment is capital. That is the capital with which the company is constituted. But if the legislature, recognizing the way in which the whole world of company law is going, decides that we won't apply that principle, we'll use a solvency statement instead, why does it change the nature of what has been entered in the company's accounts and recorded as part of its capital? I say it doesn't make a heap of a difference. The payments, as the agreed statement of facts state, and as of course necessarily therefore the First Tier Tribunal decided, said that these payments were debited to the share premium account. Now, if you want to see what was said about that in First Nationwide, one needs just to go to the Upper Tribunal where this issue was referred to. And I think it's on page 630. Let me see if I'm right, or maybe no, 636 possibly. If I could ever get to 636, I'll tell you if that's right. Obviously not. My apologies. Yes, sorry, it's 613.
613.
613.
613 of?
This is First Nationwide in the Upper Tribunal.
613 of the authorities.
Of the authorities, my apologies. Of the PDF bundle.
Yes.
We can see that at paragraph 30, having discussed some of the authorities, the Upper Tribunal says those eminent judges had no difficulty with the proposition that a dividend could be paid out of those sums, a premium paid on subscribing for shares. It did not clearly strike them as an inapposite word to use. Of course, in talking about those sums ranking as profits available for payment of a dividend, Harman J did not mean that the actual monies paid as dividend had to be paid out of the actual monies paid to the company. He was talking about an accounting exercise, so that an actual dividend must be paid out of actual profits, provided that they are within the company sufficient profits according to its accounts to support the dividend. that if a person speaks of a distribution, to use a neutral word, being paid out of share premium account, what is meant is that the actual distribution will be debited in the accounts against and thereby reducing pro tanto that account. That is precisely what is agreed happened in this particular case. Glencore debited the payments that it made to shareholders for the Glencore dividends to its share premium account, which was one of its capital accounts of Glencore. And there's what they say further down, although it's not on that page, whilst it's not exactly the same, but it has the same issue. They at 33, the Upper Tribunal discussing, has something that was a dividend before you had maintenance of capital principle still a dividend after you had a maintenance of capital principle. They say this is not to say that the ordinary meaning of the word dividend has changed. Suppose, for example, that jurisdiction X had in 1947 and all times thereafter a statutory company code identical to the pre-1948 English code. Prior to the Companies Act 1948, a distribution, being a payment out of distributable profits, could be made in both jurisdiction X and in England out of the share premium account by way of dividend. This Companies Act 1948 prevented such distributions being made by way of dividend in the case of an English company, but the company in jurisdiction X could continue to make such distributions. Those distributions remained dividends within the ordinary meaning of that word. The Companies Act 1948 did not alter the meaning of dividend. What it did was treat what was at common law was a distributable profit as no longer such, so that it could no longer be paid out as a dividend. As Duff's settlement shows, the consequence of the change in this way, that share premium account could be distributed, was that the receipt in the hands of the recipient was capital and not income. In exactly the same way, if you've got something that's in your company that's recorded as part of your company's capital, and on day one you can't distribute it, and on day two you are allowed to because the company's removed the maintenance of capital provision and has adopted a solvency statement. Why does that alter the nature of what is being paid out and debited? On day one, it was a liability to shareholders on capital account in the balance sheet as X. And on day two, that liability was reduced by the amount that they had been repaid. As I said, if we were talking about a loan that had been paid for the acquisition of the Glencore business by Glencore PLC, nobody would give a second thought to it.
Your analogy to a change of law after you've received capital on day one and then there's a change of law so you can distribute on day two doesn't quite apply in this case, does it? Because Glencore was incorporated and issued the shares in question after the major changes to Jersey Company.
Indeed, but nevertheless, as I've said, it's difficult. I cannot conceive of an argument. If you're having to ask yourself, is this of a capital? I can't conceive of an argument which attributes an income rather than a capital nature to what Glencore buys when it buys the business and issues the shares as consideration for the business that it's buying at its current market value as set by the market. And then it's recorded in Glencore's accounts, its share premium account, and so long as it sits in that account, the legislation in the company law in Jersey regards that account as a capital account, and it says that what sits in that capital account is paid up share capital. Now, how does it suddenly, on being returned to shareholders, cease to be paid up share capital other than by reference to the amount that's debited to that account for the payment that's made? Why, on what basis is that not of a capital nature?
Could I ask you, it's not exactly following your current line of argument, but just something just more fundamental. it had been your case that the Glencore distributions were not dividends, but that's no longer for us.
The tribunal's decided against us.
You've decided against us. What, if any, are the consequences of the fact that we're talking here about dividends? Dividends are distributions of profits.
Well, thank you, my lord.
I mean, I just want to understand at a quite basic level whether there are any consequences from the fact that we're now here talking on any view about dividends. And what does the word dividend import that might be of interest in deciding whether it's a dividend of one sort or another?
Well, my lord, we'll come to that to an extent when I just deal with Lonmin shares, the distribution of Lonmin shares.
Well, could you come
there
to
we
it to a
do
very
say
short
that's
extent
not-
now so that I can fit it into my understanding of the argument?
Well, my lord, you put your finger on the issue when you said dividends are a distribution of profits, because of course the whole argument in First Nationwide, or one of the arguments, was that these were not profits, so-called. They were amounts that had been contributed for the shares on their issue.
Well, I'm looking at paragraph. I mean, you took us to the Upper Tribunal. I'm looking at paragraph 25 of what it said, which seems to contain a basic statement of principle at the head of that paragraph. That there are
That's
two ways in which you can make distributions.
Yes, well, my lord, but what you have to read, the first line of paragraph 25, it says one feature of English company law, but we're not dealing with English company law, we're dealing with Jersey company law.
Yes, I take that point, but does all that considered, would it, if we were only talking about English company law, follow that by calling something a dividend, it would be treated as, it would indicate that it was a distribution of profits? Because that doesn't sit so easily with as a return of capital that you had put in the beginning.
Historically, of course, broadly speaking, derived from Trevor and Whitworth and so on, you could pay your dividends out of anything that wasn't part of the share capital of the company. In other words, in those days, Trevor and Whitworth, you're talking about effectively the par value of the company, because that's the only sort of company you're talking about. And there may be issues about unlimited companies, but, and of course now under the Companies Act, I'm sorry, I need to go away and mug up on all of some of this, but now under the Companies Act, of course, you have to pay dividends out of distributable profits. So I mean, so from time to time, the Companies Law does sort of say what it is you can pay dividends out of.
If we were sticking with our law, and I perfectly understand that that's not the point, but if we're staying with our law, is it the character of a dividend that it is a distribution of profit from one source or another that the company is able to make? That is the character of dividend, and it's taxed annually.
Prima facie, that is what is ordinarily understood.
Right. Well, if that's I mean, I don't need to go much further just to understand that that's the general picture here. The effect of your submission is that it isn't the general picture or the specific picture in Jersey. That you can pay a dividend as a means of reimbursement of capital.
Yes. The argument in relation to the Glencore dividends was that under the Jersey law, it does not tend to refer to dividends at all. It refers to distributions, which are, broadly speaking, any return of assets to members.
Well, there's a difference between, as I understand, between distribution of profits and return of assets, whatever law one's applying.
Yes, but the tax legislation with which we're dealing is legislation which looks at a dividend and asks, has it got a capital nature?
Yes, I understand that that's the question. I was just wanting to put on the table so that it can be considered and, if necessary, put in the bin, the question of whether the now established fact that we're talking about a dividend has any internal content in English law or in Jersey law that provides some pointer to its nature, whether it be income or capital, because dividends are not the same things as distributions nor repayment of capital.
And that of course is why we say the Lonmin distribution is not a dividend, but
Yes.
we
So it matters.
we reckon, well, so what is always not a dividend for the purposes of section 402 of ITOIA is of course a matter of what we regard, English law regards as dividends, and for the reasons given in the upper tribunal, first tier and upper tribunals, based on the analysis of this in First Nationwide, it was not thought that it was an issue that we could appeal here on the basis that these were would ordinarily be recognised as dividends, but nevertheless dividends of a capital nature.
Thank you.
I'm not sure whether I've helped you significantly about that, but
No, I have understood. Thank you.
Sorry, I now need to think where I should next take you. I mean, it's Companies Amendment number 9 that we're discussing, which is at 227 in the authorities bundle. And what is absolutely clear, because it was stated, you know, in the states of Jersey when this was being legislated, that as the minister explained to the states, to the members of the states, the proposed changes reflected up-to-date thinking and sweeping away outdated concepts, such as reliance on share capital in order to protect creditors and moving towards solvency statements. So there's no...
Is that referenced somewhere in your authorities bundle?
Well, I'm grateful to you, my lady. I must apologise. It was in the experts' reports had huge appendices to them, which were not part of the supplemental bundle, but we can certainly produce that if
If
you
you're going
would.
to read something like that out, I
Yes.
would be grateful to be taken.
I can. It was before the upper tribunal, but has not, as far as I could find its way into the bundle. But I can certainly arrange for
But
that.
it's also not a finding of fact of the FTT.
I was about to say, I'd be grateful if Mr. Gammy can actually point to any evidence that one can take that into account, because I'm not aware of any.
Well, just in relation to that point by my learned friend, if you go to HCA, which is an authority in the court, you'll see that the courts, in the Jersey courts, in relying upon these things, just as we do in our jurisdiction, do allow regard to be had to what is said in Parliament and in explanatory notes and the like. It's
There's one HWA.
Yeah, sorry, my apology. I keep calling it HCA. HWS. It's 863, and although it is cited for what it says about when you can, as a matter of Jersey law and interpreting provisions, go to use a comparative approach, I think if you look at it, 2 points it makes is indicates that Jersey courts accept evidence of foreign law, which of course would include English law, just as we do. But I think also if you go through it, I can't immediately tell you where, but I think it also refers to explanatory material.
Just while Mr. Gammy is looking for that, can I just understand that he's actually making a submission on Jersey law? He's not pointed to any expert evidence which says this is the effect.
Well, except of course this was all part of the experts' appendices to their reports.
I accept it's an appendices, but what I'm after is evidence. If it's a pure submission, Mr. Gammy says I'm able to make that. that's a submission you can make. Obviously, I can respond to that. What I'm just trying to do is tie this back, because this is in theory all findings of fact. What I'm trying to do is tie it back to a finding of fact, or at least factual evidence before the tribunal.
Well, perhaps I can provide the pointer in HWA rather than take up time now in due course. But I mean, my learned friend obviously relies, as their skeleton indicates, on the fact that this is somehow all findings of fact that somehow we can't, you cannot go behind. I don't know whether you want me to deal with that point now, but obviously it's a point that would be pretty extraordinary if this court were not able to look at the Jersey law, which is obviously has close resemblance or familiar concepts to English law, which is in English, and where the ultimate court that would have to decide on what it means is the Privy Council. Those are the sorts of principles that are derived from the recent Privy Council decision of LOPAG, which was, of course, also referred to in other Supreme Court decisions recently as the approach to look at evidence of foreign law, which is, as is well established, evidence of a particular nature when it comes to the facts. This tribunal, or this court, is as well equipped to look at the Jersey law and reach a conclusion on it.
Just on that, can I make sure I understand what you would say, and you may regard it as a reply point? You would say that the spectrum in LOPAG, which allows an appellate court to have a really good look, at least where the system of law is akin to English law, would you say that that applies in the same way when we're hearing an appeal from the tax tribunal on an error of law as in other appeals?
Well, I can't immediately think why would not. If you're dealing with evidence and so on, why the ordinary rules of evidence, including that about expert evidence of foreign law, not applicable in the tribunals than they are here?
It's not the question of rules of evidence. The point is that the appeal, as you know, is on for an error of law only. And the point being made against you is that these are findings of fact.
Well, I'm more than happy to demonstrate by on the basis. I mean, if the recent case law in Edwards and Bairstow obviously suggests that, you know, if no account is taken of particular relevant aspects of, you know, that have led to a factual conclusion, then that's an error of law.
Yes.
It would be surprising if that wasn't the case. In this particular case, the revenue, the only basis upon which a view could be arrived at on the expert evidence was obviously by reference to the revenues expert, who spent the large part of his expert report looking at English case law. Now, I would be astonished if it's not within the competence of any tribunal, and certainly this court, to look and see whether what he was actually saying about the English case law, when I say made sense, but added up to whatever conclusions he arrived at. In exactly the same way as I would say it's perfectly competent for this court to look at the foreign law. Why should tax and the tax tribunal be somehow different from any other approach to litigation in deciding whether in fact, on the basis of what was being looked at and the opinion that was being expressed, it was one that the person expressing the opinion was able to arrive at on the evidence. The evidence of Jersey law is before us.
Well, can we just think about this? You made a proposition a moment ago, which is that we're as well able to decide this as the tribunals were. No, the tribunals had expert reports, which I see are in our bundle, but nobody's referred to them in any detail. There was oral evidence from both of the experts. And so in effect, the first tier judge got under the bonnet of this, right, and came to a conclusion, rightly or wrongly, reached a conclusion. So, I mean, even if one was to exercise a degree of latitude for the reasons that you give, exercise a sort of Edwards and Bairstow light approach to this because of the limitations of the statute, I don't see that we begin to have the material on which we could unpick what the first tier tribunal judge found, simply for lack of data.
Well,
Isn't that a real difficulty here?
no, my lord, I would disagree with that respectfully entirely. You have the Jersey statute in front of you. You have the expert reports before you. The expert report, certainly so far as the revenue expert was concerned, was considering was seeking to derive a series of principles from the English case law, all of which are based on maintenance of capital. Now, in this particular case, he did not regard it as relevant to look at or to take into account the fact that Jersey had no par value companies and that part of the capital accounts of the company included a stated capital account of a no par value company. That's one aspect. In relation to the comparative exercise that he was doing, he was looking at cases which bore no comparison to what the Jersey legislation was, in the sense that they were based on the principle of maintenance and capital.
Yes.
Whereas, of course, we're looking at a jurisdiction which does not adopt the maintenance of capital in the particular periods we're looking at. Now, I have to say, are you seriously saying that this court has no scope to look at and consider whether those were conclusions that he was entitled, that the First Tier Tribunal was then entitled to rely upon to the extent that it did?
You ask a question, and the answer is, I was expressing the view that even if you were successful, I'm not understanding. I mean, I'll tell you what my next questions are. Where does this appear in the grounds of appeal? Where most conveniently does it appear in your skeleton argument that you are seeking to overturn the findings of fact in relation to Jersey law?
Well, my lord, I would have thought that was going to say.
But if you're going to say it's implicit, that further increases my difficulty in considering that this is an exercise that we could, as it were, accompany you on. It may very well be that it is here, but I would like some, as it were, pitons in what is usually quite a steep rock face to understand how we are to embark upon this climb with you.
Well, my lord, obviously there are, I haven't got to the First Tier and the Upper Tribunal decisions
at this
and
stage,
said why
because
they're wrong.
we have, I have an eye on the time as well, and I don't want, in a sense, us to mislead you as to the use of your time, because we need to understand what's truly on the menu here. That looking at the grounds of appeal, I'm sure there may be somewhere where you would say this is stated, but I would rather not comb it myself. I'd like to rely on your guidance as to where in your grounds of appeal and subsequently where in your skeleton argument do we have the basic equipment that we would need in order to overturn a finding of fact. I mean, we sit all the time on appeals against findings of fact which don't face the difficulty that you have to do with the tax tribunal system. And we're armed with the necessary information. At the moment, I'm just not seeing where we have either the argument set out or the evidence in support of that argument in a way that we could fairly do it justice.
On the basis that this is a finding about foreign law, the evidence you have is obviously the actual foreign legislation, which is if you take LOPAG, you know, there's a scale of these things, and the question is, what would a final court of appeal decide in respect? You know, was the treatment of this particular amount or this share premium as part of Jersey law? You have the legislation, which I mean, in LOPAG, I can't believe they had anything else other than the legislation. And if you look at these cases, LOPAG and the like, they're looking at the legislation. They're saying, are we allowed to interrogate and look at this legislation and question the conclusions that were arrived at by the judge in respect of what that legislation did? Now you have the legislation, which I've taken you through. And I will obviously, in due course, come to the question of whether or not the conclusions that the First Tier Tribunal and the Upper Tribunal reached by reference to that was an appropriate conclusion, given that this is an issue of law, question of law as to what is a dividend of a capital nature under the UK statute. Now, the whole basis of our skeleton argument is that that's not, and indeed the grounds of appeal is that they were not appropriate conclusions that could be arrived at based on the foreign law that was in question.
Yes, I'm looking at page 15 of our bundle.
Sorry, core bundle.
Yes, yes. In which paragraph 8.1 is your first submission under Grand 1. Now, is that where we find the anchorage for this argument? Or is it elsewhere?
My Lord, yes, so ground 1 obviously refers to the legislation under which and the conclusion that were reached in respect of it. But I mean, if you go back to Edwards and Bairstow, the facts of the case were perfectly clear. The issue of law was, well, did those facts allow the general commissioners in those days to conclude that this was not a trading transaction, to which of course the House of Lords says, well, that's not a conclusion you can arrive at on that basis. In the same way, or in a similar way, here we have evidence of foreign law which takes the form of the foreign legislative provisions and what was done to them. And the question is, if you're putting it in Edwards Bairstow's time, what was the conclusion that the First Tier Tribunal and the Upper Tribunal reached, one that they could properly reach on the basis of that legislation? And inevitably, that's a question of law. So here, based on the legislation and what it provided, was it a conclusion that the tribunals could appropriately arrive at, having regard to the Jersey legislation, which you have in evidence before you, and being evidence of foreign law as recognised in LOPAG? I would just say that if you want to draw a spectrum of case where you can actually look at that law and exercise your own judgment as to what it means, it's difficult to think that there's any other case that's closer to the end of that spectrum in our favour than a case where the Jersey expert relied on English law, case law, and where the ultimate court that would have to decide the issue it arose in Jersey is the Judicial Committee of the Privy Council. On what basis, where on that spectrum does it lie beyond that to say that it's not competent for this court or indeed the Upper Tribunal to look at the legislation and exercise its own expertise to decide what that legislation means?
I don't want to prolong an intervention that I promoted, but as I understand it, you would have to show in one way or another that the conclusion that the tribunals reached was not one that they could not properly reach on the information before them in relation to the state of Jersey law.
That would be a combination of the reasoning that they used to arrive at their decision, which might in itself indicate an error of law, just as in Edwards and Bairstow, the reasoning of the commissioners meant that they couldn't arrive at the conclusion that this was an investment, not a trade, that being an issue of law.
So it's yes, is it?
Whether something's a trade is a question of law.
It's yes to what I'm asking you, is it? Namely, that your task is to persuade us that it's a conclusion that the tribunals could not properly reach.
On the basis of their reasoning. Either there is some element of their reasoning which one can point at and say that must be wrong.
And can I make clear that I was not suggesting that this court lacked competence to deal with the issue. What I was saying that I was doubting that we had capacity to deal with it on the basis of the information that has been put before us, because there was evidence about this. And speaking of myself, before just saying that the first tier judge could not have reached this conclusion, it was not properly open to her, it would surely involve a much more detailed examination of the evidence that was before her about this, not simply a high-level discussion about the framework of the legislation.
No, but the framework of the legislation is the factual basis on which conclusions have to be reached. I mean, that's what, I mean, if you're thinking about it in terms of the Supreme Court in Centrica, it's sort of saying, well, you have to identify what the principles are and apply them to the facts of the case.
Yes, I appreciated that's necessary, but my concern is whether it's sufficient. That's my problem at this point, but I don't want to prolong the intervention because you have other topics to cover as well.
Indeed, I do, my lord. I'm sorry.
And I think, Mr. Gannon, that possibly where you were going and possibly where might assist us all, including Jackson, is now, I think you're going to take us to show us where those errors in approach occurred in the FTT and the UT.
I can certainly go in that direction.
Is there anything else before we do that? You didn't take us fully through all the amendments to the Jersey law. Is there anything, I mean, they're fully set out in your skeleton. Is there anything critical to which you wish to draw our attention?
Yes. If we just go to, sorry, let me just find my place in my notes. So amendment number 9 is 227 in the authorities bundle.
Explain the effect.
And the effect was obviously, the intended effect and was to move away from the maintenance of capital and adopt the solvency statements. So Article 39 of the Act, which is the one under which it says that share premium is to be treated as share capital, was unamended, so that remained as the same. Article 61(3) of the, which is the reduction of capital, was amended to insert words, which we see on page 231. You see in the middle of that page says Article 61 and amended in Article 61 of the Principal Law in paragraph 3 after the words paragraphs 4 and 5 that to be inserted the words or in case of a reduction in capital comprised of a distribution made in accordance with Article 115. So that was again explained as including in the list of capital reductions that capital reduction could take place under Article 115, and Articles 115 and 114 and 115 are found at 234. So again, distribution again is extended, covered, defined to cover everything, every description of assets, of distribution of assets to a member as its members in cash or otherwise. Distribution does not include a distribution way of issuer's shares, redemption, reduction of capital by extinguishing or reducing liability of any of the members on any of the company's shares in respect of capital not paid up, etc. And then in 115, it says that
I think we're probably fairly clear about that. So just,
yes, it's on page 1235, where it says a distribution made in accordance with this article is debited to a share premium account or stated capital account of the company or any other account of the company other than the capital redemption reserve or nominal capital account. And as I said, one reason why nominal capital accounts can't be produced under by way of a distribution under this is because it involves an amendment to the article, to the memorandum of association. That's at least one reason why that would be there. And then you have in your bundle, sorry, at 929, I think it is, the States of Jersey Economic Affairs Scrutiny Panel, which, as you'll see from reading that, this concerns a subsequent amendment, Article 10, that was made shortly after Article 9.
Sorry, what are you reading from?
I'm reading from the Authorities Bundle, page 929.
Thank you.
Lady. So as you see, it says, obviously, at the last state sitting, I was asked that the amendment number 10 of Companies Law be referred to the panel primarily because there was confusion among a number of states members as to exactly what it was doing. So it really is taking the opportunity here for your department to explain to us in more detail and just satisfy us. And once it's absolutely clear, we can go back and report to the Assembly as a whole that we've looked at it and are quite happy with it. And that that then was the Minister explaining to the committee, which the states had referred this matter to explain what Amendment 9 and Amendment 10 were supposed to be doing. Amendment 10 is, just find, is at 241. And that made what were described as minor amendments to Amendment number 9, they're covered in the joint memorandum by the Jersey experts. And this was where Article 39 was amended by the addition of Article 39(3)(e) to the effect that a share premium could be employed in making a distribution in accordance with Part 17. In other words, a distribution as a general distribution under Article 114 or 115. And it was also specified, so that's in 244, you can see that amendment in 244 to 245 at the bottom. And then in Article 39A, which of course is dealing with no par value companies, there's added that a stated capital account may be applied by the company for any purpose for which a share premium account may be applied by a par value company. So the two are, if you like, assimilated, but they're treated the same, and we've seen what a stated capital account for a no par value company is. And then on page 245, you can see that there's added to Article 58C, redemption, purchase or cancellation under Part 11, not a reduction of capital. Redemption, purchase or cancellation by a company under this part of its shares is not, for the purposes of Part 12, a reduction of capital. And the same language is added to Article 61. The words in Article 61 that were added by 9, saying, or in the case of a reduction of capital comprised of a distribution made in accordance of Article 115 are deleted. And
well, that suggests to me that it was clarified that one argument, often going through it like this, rather than just looking at the present legislation, it may suggest that the legislature believed that a distribution made in accordance with Article 115 should not be described as a return of capital.
For the purposes of Part 12. Those words in the First Tier Tribunal, this is set out, but the words for the purposes of Part 12. The mere fact that something isn't a reduction of capital for the purposes of Part 12 doesn't mean that it's not a reduction of capital for any other purpose. And the explanation provided is that it was being made clear that each of the procedures, the separate procedures in Part 11, Part 12 and Part 17 worked, when I say independently of each other. In other words, you didn't have to comply with, if you were making a reduction of capital under Part 17 or a reduction of capital under Part 11, you didn't have to comply with any of the requirements under Part 12. And of course, in amendment number 11, that's within the period in which we're dealing, the requirement for maintenance of capital under Part 12 was also removed and just replaced by an insolvency statement. So over the course of amendment number 9 through to amendment number 11, Jersey company law dispensed with the concept of maintenance of capital. But that just takes one back to the question I posed before lunch and immediately after lunch is, does something that is capital, it's always been recognised as capital, change its spots or change its character because it can be returned under some other provision of the Act, including a provision which would characterise it as a dividend. And the mere fact that you say that something's not a reduction of capital for the purposes of Part 12 doesn't mean that it isn't a reduction of capital when what you're dealing with is the capital accounts and debiting what is treated as capital under Article 39(4) of the Act, so long as it sits in share, so long as the premium sits in share premium account, you're told this is equivalent to paid up share capital of the company. The stated capital account of a par value of a no par value company, I would submit, cannot be anything other than the capital of the company, unless you're going to say this company doesn't have any capital. The stated capital account of the of a no par value company is equated or can be dealt with in the same way as share premium. Are we now saying that a no par value company doesn't have any capital? I say that doesn't make the slightest bit of sense at all, any more than in Edwards and Bairstow deciding that buying a mill plant and selling it in only 5 or 6 lots couldn't be anything other than trading and was not investment. Whereas that where if we're having to think about these things in Edwards and Bairstow terms, you know, at what point does one look at simply at the facts, in this case, the Jersey company law legislation, and say that the conclusion that was reached, that this was an income dividend and not a dividend of a capital nature, was not one that was capable of being reached, having regard to the Jersey legislation, which obviously treated share premium as one of the capital accounts, and so long as it sat in the capital account, was part of the paid up share capital of the company. What has it got to do with that question as to whether it's a capital of nature? That the Jersey says we don't have Trevor and Whitworth and maintenance of capital principle because that's outdated, and modern law says that the solvency statement is a better protection for creditors. It's got nothing to do with whether or not what is the capital of the company for the purposes of the Jersey Companies Act. The reason why Trevor and Whitworth and maintenance of capital and the legislation for share premiums came into existence was because share premium was capital in nature. That was the Cohen report in 1943 or 45, which again is in the bundle. So it wasn't that making it non-distributable gave it a capital connotation or nature. It had a capital nature, which was why the original provision for protecting creditors prohibited a distribution out of share premium and share capital. But when the world moves on and says that's no longer the best way of protecting creditors, it doesn't alter the nature of the capital that you remove that particular restriction on returning part of the paid up capital of the company to shareholders. It still remains capital, because that's what it is. Just as buying plant and selling it in 6 lots is trading. So, my lords, if we just go to the First Tier Tribunal decision. It's in the core bundle.
Divider 10, page 107.
Now, my lords, the First Tier Tribunal decision if I can put it this way, is full of infelicities in the way in which it summarises the situation under the Jersey Company Law. But I'm not going to waste your time just sort of trying to pick holes in individual bits of it. But if we go to the conclusions, so on page, I'm just picking out, so on page 120, it's sort of summarising some of the things that the revenues expert witness said. We can turn in due course to his report and some of the things he said. So just at the top of page 120 we see, it says, Mr. Wilmot accepted that it was impossible to be certain about the correct interpretation of the Jersey legislation, and that it was hard to reconcile the Jersey law post-1968 with the pre-1948 English company law. The maintenance of capital principle had been abandoned by Jersey law, but it is not clear that even prior to the abandonment, Jersey law was equivalent to the pre-1948 English law as considered in Duff's settlements. Its conclusion, however, was that for Jersey law purposes, share premium is essentially an income account, with payments derived from that account also being of an income nature. Part 12 distributions are an exception to that rule.
Mr. Gammy, just pausing here, I have read this section of the judgment as not being part of the judge's findings of fact, and we are interested in the findings of fact, which in general come much later.
Well, indeed, my lady, and that's part of the difficulty with the First Tier Tribunal decision, that the judge doesn't really make clear findings of fact about Jersey law.
I think, if I may put it this way, I think there are findings of fact, but they're not always grouped together, and they
Yes.
are located in different places. One question, of course, is whether it is necessary to your appeal to actually attack those findings of fact about Jersey law, or whether you can rest your appeal, even if those findings of fact can't be disturbed, on whether the FTT applied the right interpretation of Section 402, which obviously is properly
Yes.
a matter for this court.
Well, ultimately, ultimately, of course, the question is whether or not the judge arrived at the right decision on Section 402. That's obviously correct. But insofar as a conclusion on Section 4024 also has to take into account how Jersey deals with the capital of the company, in other words, whether or not this is part of the capital of the company, then I think one has to go into that as well. But it's not at all clear what the judge actually decided on some of that.
Can I make this point? I think my impression from a quick look at the expert evidence and what's summarised here is the experts may well have strayed into the matter that was actually for the court, for the tribunal to decide, which is the English law
Indeed.
question. I'm for myself interested in what can really be identified as findings of fact, and I'm not sure that your appeal depends on disturbing those findings of fact.
No, well, I'm grateful to you for that indication, my lady. I mean, the final, as I'll take you through the sort of final analysis in the First Tier Tribunal decision, but it's somewhat confused, and it doesn't really seem to depend upon any findings about Jersey law in many respects, or at least it's not clear what exactly she is or is not finding about it, because, and that I think is reflected in the Upper Tribunal decision, because in the Upper Tribunal decision, they make this what I regard as an incorrect statement about, they can't look at the the Jersey law. It's all a question of fact and they don't have jurisdiction to look at it, which for reasons I've already suggested, I think is just wrong. But they say that the decision didn't really depend upon the findings of what the Jersey law was by the, as the experts said. It was dependent upon the case of WPP, which is a Jersey case under which a company applied to the court in Jersey to transfer part of its share premium to a revenue distributable account. In other words, effectively to take it out of capital and put it into ordinary distributable profit. Now, that again, I when I say I don't see that, if that leans anywhere, it leans in our favour. That it indicated that at the time that the application was made to the Jersey court, it was thought necessary, or at least certainly advisable, to move something out of the share premium account, which was part of capital, into an ordinary distributable reserve. And I don't see how it points in a different direction. But my lady, sorry, just to go back to your original book. So page 131 of the core bundle in the First Tier Tribunal's case, we have findings of fact, a very short paragraph, section 178. On the basis of the evidence seen and heard at the tribunal, I'll make the following findings of fact. If Glencore had chosen to pay the distributions in reliance on Part 12 CJL, the distributions would not have been treated as distributions for Jersey law purposes. Well, okay. The account from which Glencore debited the distributions was a capital account. Well, that was self-evident, part of the agreed facts. For Jersey law purposes, that does not necessarily mean that the distributions were debited to shareholder funds. I have to say, that's, so the judge has referred to shareholders' funds earlier, but it's not at all clear
I think
what
she's
exactly
referred
she
to it
means.
as meaning share nominal capital.
I think that's probably the best guess one can make, that she's thinking of shareholder funds in the sense of the nominal capital attaching to the but that's a statement of the self-evident. I mean, it's not quite clear why she says that, because it was agreed and a fact and indisputable that these distributions were debited to share premium, which was a capital account. So it's not quite clear why she's saying for Jersey law purposes that does not necessarily mean that the distributions were debited to shareholder funds. Because obviously, if it means the par value of the company, they obviously weren't. I mean, the par value of the company as 1 cent shares wasn't sufficient to pay these distributions. It had to come from share premium. Under the CGL 1991, the only funds from which distributions cannot be made are the nominal capital and capital redemption reserve funds of a Jersey company. Well, that's because they are not specified as funds to which you can debit a distribution under Article 115, but as Mr. Beard's expert had explained, one reason for that at least was because it would involve an amendment to the Memorandum of Association.
Just to be clear about how I'm thinking, I do not read the only findings of fact as being in 178. I have got a list of other paragraphs that I think at the moment involve findings of fact of Jersey law, and I'm sure you've both looked through the decision with that in mind. So rather than spending too long on 178, I think it's important that we try to grapple with the rest.
So I don't think there's anything about 178 apart from the rather opaque reference to shareholder funds that anybody had disputed anyway. So then she goes on to deal with payments made by Glencore dividends, were the payments made by Glencore dividends, which, for the reasons that she's given, that was eventually decided against Mr. Beard in the Upper Tribunal and has not been appealed.
Well, indeed, but there are relevant findings, I think, about Jersey law in this section. So 196 and 197.
Let me just find it. So 196. For Jersey law purposes, those are distributions made under Part 17 to Mr. Beard in his capacity as a shareholder of the company. Well, I don't think that's...
Well, I'm not sure of the best way of dealing with this, but I can give you a list of the, rather than take them all in detail, I can give you a list of the paragraph numbers that I've jotted down, I think may involve findings of fact. I'm not sure you've got time to go to them all at the moment, but I'll give you the list, and we have got tomorrow if it's necessary for you to respond on any of these. So earlier in the judgment, paragraph 66, you've referred us to 178. There's 196 and 197. There appear to me to be more findings between 199 and 285. Potentially also between 211 and 213. And 251.
Do you want me to deal with those now?
Well, I'm mindful of the time, Mr. Gemmey. You said you would complete your submissions today, so I need to allow you time. We need to allow you time to make those submissions, and we really do want to understand what you've got to say about the errors in the decisions below.
Yes, yes. Well, and also, well, to the extent that any of those findings depend upon what the revenues expert, Mr. Wilmot, said, presumably you'd like me also to say why, as shortly as I can, why Mr. Wilmot's conclusions are not to be relied upon.
I think you need to make your submissions as you wish, and if you, as I say, if you need to respond on the list, I think it may be not appropriate to try to do that this afternoon, because I think it will slow matters up too much.
Well, let me...
Just for Mr. Gemmey's benefit, I had two other paragraphs which might be just useful to have to mind. It's 233 and 248.
Well, maybe, if Mr. Yates, if you're going to deal with findings of fact tomorrow, then Mr. Gemmey obviously has a right to reply.
Absolutely, but I, as a matter of order, I'd like to know what the criticism of them is before I respond to them.
Yes, but that's just why I want to hear we want to hear the submissions as to why the decision is wrong.
If we go on to trying to pick up where best to deal with these things. The conclusion that the tribunal reaches ultimately. Perhaps I can pick up that. So on page 140 of the First Tier Tribunal decision, the judge starts off by saying, well, First Nationwide points out it's the mechanism of payment that's important, then at 246, the relevant payment mechanism for these purposes in Part 17, in particular Article 115. And she then says the expert disagreed about the character of that mechanism. I'm not actually quite sure of what she's quite deciding or thinking about there. The parties did agree that Part 12 is a mechanism for returning capital to shareholders. Of course, it does not necessarily follow that Part 17 cannot also have that character. However, in my view, it is more likely that the Jersey legislature intended these to be discrete rather than overlapping provisions. Well, of course, they were discrete and not overlapping provisions. That was the point about the amendment number 10, that each should operate separately in the sense of if you were doing a Part 17 reduction of capital, you didn't have to use the mechanism, you didn't have to engage the mechanism of Part 12 or Part 11. They all operated separately. So I don't know that there was any disagreement about that, but that doesn't, in my submission, tell you that what's coming out is not capital. And then Mr. Wilmot suggested that while the default position is the payments made under Part 17 are income payments, it's also possible for a capital dividend to be paid under Part 17, subject to very clear tracing exercise being possible. This was the proposition in his expert report, that actually it might be possible for capital to come out if for example, you subscribed shares at a premium, and then before you'd actually done anything with the money, you gave it back. You distributed it back under Part 17. I'm not quite sure at what point in his view of things, things cease to be capital.
I'm not sure it's worth spending a lot of time on that, because I suspect that's one of the areas where the experts would straying into matters that are properly questions of English law.
Indeed, and of course my challenge to, not a lot, but a certain amount of Mr. Wilmot's evidence was that actually he was trying to answer the question that was for the tribunal, not
Indeed. But I'm not sure how much that helps us now.
No. Well, then at 248, the tribunal judge says, I've proceeded on the basis that payments made under 17 must be different than payments made under Part 12. They're different mechanisms producing different legal effects. When I say they produce different legal effects, of course, as a matter of Jersey companies law, they produce exactly the same legal effect in the sense that they're both debited to the capital account in the share premium, and they reduce the balance of that capital account. So if she's meaning that those payments have a different legal effect for Jersey law purposes, plainly they don't, because they have an identical result in reducing the capital account by the amount that's debited to it. And then she says all payments made under Part 17 must, for these purposes, have the same character. That, of course, was, when I say direct, was contrary, I think, to the evidence given by the experts. Certainly, Mr. Wilmot, even he accepted that dividends under Part 17 were sort of subcategory of the distributions as defined. As we've seen, distributions is always defined in terms of covering any return of assets by the company to its members. So it's effectively an all-extensive provision rather than one that is limited in any way other than by the exceptions that are made to it. So there she's proceeding here, I say, on a basis which is plainly unsupportable, certainly as a matter of the Jersey law and the Jersey evidence that was given in respect of it. And insofar as if she's thinking about things from the perspective of the UK law, that must also be wrong, because that suggests that all payments under Part 17 must either be, if they're all the same character, there isn't such a thing as a dividend of a capital nature, because by definition, Section 402 says that there are some dividends which are dividends and therefore within the charge to income tax, and there are other things that are dividends of a capital nature. So even from a UK perspective, if that's what she's thinking about, she must be wrong, because
Well, that assumes that the concept of dividends of a capital nature has some real effect in relation to a Jersey incorporated company. One possibility is that the concept of dividend of a capital nature may not apply in a system such as that of Jersey, but may apply under certain other legal systems. I mean, we touched on it earlier. I know you said, well, Justice Moses said the description in court holds of a dividend was wrong, but, you know, at least for some purposes in Italy, the payment in court holds was described perhaps loosely as a dividend, but was still of a capital nature. My point is, it will depend on the local law.
But I'm sorry, I'm just trying to process how that makes sense in the context of what the judge here says, that all payments made under Part 17 must, for these purposes, have the same character. If something is of a capital nature and something is of an income nature, do they have the same character? I would say not. That's a sort of natural understanding of the legislative language. The legislative language obviously envisages that you can have a payment that is a dividend, but one is a dividend of income and one is a dividend of a capital nature. And the question is, what is of a capital nature? Now, that's from an English perspective, but if that's applying, that must be wrong, surely, even if you're sort of then applying it to Jersey law. I mean, Jersey, if she's saying that every payment under Part 17 must be an income distribution, is that? I'm just trying to process not only the point you just made, but a distribution under Part 17 comprises everything, any return of assets in any circumstances, as permitted, certainly at this time, by the Jersey, as a matter of returning assets to the Jersey members, and explicitly can be debited to different accounts with the company. Sorry, I'm not sure I understand the point, how you make sense of that sentence, whether you're looking at it from a Jersey perspective or an English perspective.
My point is simply that it may be more appropriate to some other systems of law. But I think we should move on.
And then WPP supports the proposition that while Jersey companies have a free choice as to the mechanism to use, that does not mean that the two mechanisms are the same. I'm not quite sure what that adds to anything. As I say, WPP was an example of the company moving share premium from a capital account onto a general distributable reserve. So it wasn't even that it was making a payment under WPP. It wasn't a payment, it was a movement between accounts in WPP. So insofar as she's proceeding on this basis, I have difficulty making sense of any of 1, 2 and 3. And then we have 249. For Jersey law purposes, Part 17 is a distribution payment mechanism. Does this mean that it cannot be used as a mechanism for returning capital to shareholders? My view is that the better view of Jersey law for these purposes is that Part 17 is a mechanism for returning funds which are distributable, i.e. neither nominal share capital nor share capital reserved to shareholders. Well, that's a statement of the self-evident, because that they are the accounts to which a distribution under Part 17 cannot be debited. But of course, that doesn't answer the question at all, because they can be debited both to the stated capital account of a no par value company and also to share premium. And of course to a general reserve or other account of the company. So I'm not sure that 249 tells you anything in particular or determines anything that answers the question as to whether or not, by debiting it to share premium, that is a repayment of share of what the Jersey law treats as capital. And then Mr. Felton points out that funds paid under Part 17 as distributions do not have to be transferred to a distributable reserve fund before they're paid out, suggesting that this means that they retain their capital character under Part 17. But it's certainly true to say that a distribution, and again, I don't think there's any question that none of the Glencore dividends were transferred to a distributable reserve fund before they were paid out. They were just paid out and debited to share premium. And then she says, I do not think that this can be correct. On my analysis, and even taking account of Article 39.4, my view is that Part 17 overrides the assimilation to capital provided by Article 39. Well, of course, as is clear from everywhere else, both in Mr. Wilmot's report and in this, assimilation to capital says, that this has to be returned. It's the maintenance of capital principle for the purposes of the creditor protection. The deeming provision of Article 94 is made subject to the ability of a company to pay a distribution made under Part 17. The legal character of share premium as assimilated to capital is broken by Article 39.3e. But of course, so long as the payments remain in the share premium account, they are subject to the provision of Article 39.4 saying that they're deemed to be share capital, and that's how they may ultimately be paid out. So payment under Part 7 cannot properly be treated as anything other than distributable profits. Well, Yes, of course, if when you say distributable profits, they are distributable in the sense that they can be paid as a distribution under Article 115, following the removal of the maintenance of capital principle as a principle. But that doesn't tell you anything about what is the character of those payments and whether or not they are in fact regarded as part of the company's capital. And what is equally said there about share premium must also apply to the stated capital account of a no par value company, which is assimilated to share premium. And I mean, it's one of the features of both Mr. Wilmot's report and, broadly speaking, of the decisions, that the provisions of no par value companies and no par value shares are not considered at all. Now, how can you reach a conclusion on the company law of Jersey if you actually turn a blind eye and put blinkers on and don't actually look at one of the fundamental components of the company's under the company's law of what is or is not treated as a capital account? I mean, I say that is, I mean, you know, turning your blind eye to, you know, a whole area of the Companies Act is not arriving at a considered view as to how that act regards share premium and how that act regards, you know, what it treats as the capital of the company, when, as we've seen, the nominal par value and share premium of the of a par value company is equivalent to the stated capital account of the no par value company. The two can be exchanged between each other, you know, according to the particular classes that you're dealing with. And I find it difficult to see how you can arrive at a conclusion on the question of what does the Jersey Companies Law treat as capital when you ignore a whole area of the Jersey Companies Law, in particular one that is so interrelated with the capital of a par value company as a no par value company, as we've seen, as I've taken you to. But insofar as she is saying that I do not think that this can be correct at 251, she can't be saying that they have to be transferred to a distributable reserve fund, because plainly they're not. They're just paid straight out and debited to share premium. That's what is the fact. And even if she's disagreeing with what Mr. Felton, or not accepting what Mr. Felton suggested at the end of 250, that they retain their capital character under Part 17 and that they're distributable profit, that doesn't necessarily answer the question as to whether or not they are being regarded as capital under the Jersey Companies Act, or are not dividends of capital nature for the purposes of Section 402. And then she says, there is not, as Mr. Felton tried to establish, any third category of payments. I don't think Mr. Felton tried to establish any third category of payments. He just said that share premium, insofar as you're looking at share premium, is not specified to be income or profits for the purposes, and it would have required explicit statement by the Jersey legislature to reach that conclusion. And that was something that was agreed to by Mr. Wilmot. So the expert evidence was contrary to what the judge is saying at the end of 251, that these were neither income nor profits for the purposes of the Jersey Companies Act. Of course, they represented amounts in respect of which assets could be returned to members by debiting the share premium. I don't think he was trying to establish some third category. If he was saying anything, it was just that the Jersey legislature has not explicitly said that, when I say explicitly said, this is capital or this is income or profits, it hasn't described it in that way, other than, of course, in the way that I've dealt with it, that it is part of the capital accounts. And then she says, Part 12 governs payments which are or assimilated to share capital. Part 17 governs any other payments which can only be distributions of profit. Well, as I say, that, when I say conflicts with both the expert evidence by both experts, that would have required express statement by the Jersey legislature to have that effect. And anyway, Part 17, a distribution under Part 17 doesn't talk in terms of distributions of profits at all. It talks about returning assets. And in a comprehensive way, any return of assets to members, any return of assets to members other than those types of transactional actions which are explicitly excluded. So insofar as she's trying to draw some conclusion there, seems to be contrary to what the Jersey expert says and contrary in a way to what precisely Article 15 talks about. And Part 17, she goes on, is not, to use the terminology of Moses J, a mechanism which is readily identifiable as designed to protect the capital of the company. But what Moses J was talking about this in the context of both the Cayman provisions and also the general case law dealing with the maintenance of capital principle. So of course Part 17 isn't a mechanism readily identifiable to identify to protect the capital of the company, because Jersey has moved away from the maintenance of capital principle. It doesn't protect creditors in that way, and obviously a facet of that, of doing that, is that capital which was previously not distributable can now be returned to shareholders without the specific protections that previously existed by way of a order of the court designed to protect creditors. But that doesn't tell you that what is returned under Part 17 is not part of the capital of the company when you look at the whole of the Act and see what it treats as capital and what it doesn't. So I think those three paragraphs not only are sort of littered with errors, but are difficult to understand or justify by reference to what we know, both through what was agreed by the experts and what we can actually read and see in the Act itself. And then she goes on at 253, applying the Ray and Lazard principle, this is determinative because the mechanism reflects the underlying legal nature of the payment as either share capital or otherwise. And then she cites what Lord Justice Moses said in First Nationwide. It says payments made by a company in respect of shares are either income payments or if the company is not in liquidation by way of an authorised reduction of capital. But of course, that's the whole point. If Article 7, if Part 17 in Article 115 authorises the company to return its capital to shareholders and debit the share premium account in doing so, or debit the stated capital account of the company, then that is an authorised reduction of capital. What Lord Justice Moses and the previous authorities are all talking about is systems where the maintenance of capital principle operates so that you can't make a reduction of capital by way of payment of a dividend. Not that she refers here specifically to dividends, just this quote talks about payments made by a company in respect of shares are either income payments or if the company is not in liquidation by way of authorised reduction of capital. It's certainly true that payments made by a company in respect of shares are either going to be income payments or they're going to be capital payments, and in this context, dividends of a capital nature. But just saying that but quoting a bit which says you can only reduce your capital by way of an authorised reduction of capital, if the company law authorises you to reduce your capital by distributing it under Part 17, why is that not an authorised reduction of capital? In the context in which Lord Justice Moses is saying this, of course he has in mind companies to which the maintenance of capital principle applies, but that doesn't mean that no other way of reducing capital is available under the specific company law in question. And of course, the point that Lord Justice Moses was making when he said this was in relation to Cayman law, where the only way in which you could return share premium was by way of a distribution as a dividend. You couldn't. It didn't fall within the category of capital, and it didn't fall within the reduction of an authorised reduction of capital. So she's certainly not comparing like with like in saying this. And again, if payments, as it goes on, if payments are made by deploying mechanisms appropriate for the reduction of capital, then they are payments of capital, which of course might be equally true of a payment under Part 17, which reduces capital. Such mechanisms can be readily identified as designed to protect the capital of the company. Well, that of course is in the context of maintenance of capital. In fact, the whole basis and tenor of the decision is that by moving away from the maintenance of capital provisions in Jersey, the Jersey was effectively saying that share premium is not part of the company's capital, when of course the whole point is that we're looking at something that is a dividend and asking whether or not it's dividend of a capital nature. My lord, I don't know whether you
You can sit till 1:15.
Yes, I can go on till.
Yes, well, how are you doing?
It is really a case of how many holes you want me to pick in the conclusions that the judge
we
here.
haven't yet touched on the Upper Tribunal
She does
decision.
not.
We haven't yet touched on the Upper Tribunal.
No, my lord. The Upper Tribunal is more straightforward in the sense that the Upper Tribunal effectively looks at all the case law, and again, I say, the foundation of both the Revenues experts' opinion, the First Tier Tribunal's decision, and the Upper Tribunal's position is that if you move away from the maintenance of capital principle, then broadly speaking, what comes out as a dividend must be income. that cannot, when I say that cannot be right, the question we have to consider is it a dividend of a capital nature? And there's absolutely no reason. So Buckley and Courtaulds, all of the case law talk about what we've just seen repeated by Lord Justice Moses in the quote in 253, that you have to have an authorised reduction in capital. But if the company law in question authorises you to return capital as a dividend, why is that not an authorised reduction in capital? I mean, I don't see how you cannot say that it's not an authorised reduction of capital. It's what the company law permits you to do with your capital. So in the case of a stated capital account of a no par value company, if the no par value company reduces its capital by returning assets to its shareholders that it doesn't need for its business and debiting that to its stated capital account, are we to say that that's not an authorised reduction in capital? When it chooses to do that, it is just debited, it's just reduced its capital. I mean, we've seen from the Act, I would say the only conclusion to reach is that the capital of a no par value company is what its stated capital account is. So if it returns part of its stated capital account using the mechanism under Part 17, it is authorised by Jersey Companies Law to return its stated capital account under Part 17. Why is that not an authorised reduction in capital? It effectively says that nothing that can be paid, the natural way of looking at this is to say that nothing that can be paid under a dividend mechanism can have a capital characteristic. And that's why the Upper Tribunal then has to ferret around in the trust context to try and find an example of something that, when I say supposedly, apparently, or a demerger that can give rise to a dividend under English law, although that wasn't the case in Ray and Lazard, to find some type of transaction that can then be said to be a dividend of a capital nature. But why should that be so? We know that although there are similarities between trusts and tax law, they are certainly not the same. So just dealing with that particular point, which of course is fundamental to the Upper Tribunal's decision, why rely on trust authorities? I mean, we see in Reed's Trustee what Lord Norman says. It's at page 412 of the authorities bundle. It's in the wrong bundle here. So page 412, it says, your lordships are not in this appeal concerned to construe the terms of the trust deed. I therefore express no opinion whether the dividend under consideration was, under the particular terms of that deed, properly treated as the revenue of the Lyfentrix. But these authorities show that the distribution of money to shareholders out of profits realised by the sale of the company's assets without any alteration in the share capital is normally a payment of the nature of income. But of course, if you pay assets out to members of a no par value company and reduce the stated capital account of the no par value company, there has been an alteration in the share capital of the no par value company. The no par value company's share capital has been reduced by the amount that's debited to its stated capital account. Given that share premium and stated capital accounts are assimilated in the sense that what can be dealt with with share premium can be dealt with for a no par value stated capital account. And given all we have seen about how capital accounts in a Jersey company are dealt with, why does a distribution in respect of the Glencore dividends, which is debited to their share premium account, not provide an alteration in the capital of the par value company? Its liability to its shareholders under its capital accounts has been reduced, whereas of course a payment out of any other reserve or distributable profits or earnings or whatever has no impact whatsoever on the capital accounts of the Jersey company. So that's what Lord Norman said. And of course, just dealing with, using these few minutes just to deal with the other points on trust law, it's certainly true that trust law has to resolve the same question. Indeed, as Lewin on trusts notes, distributions from foreign companies, the question's not wholly clear. So it's obviously trust law has to resolve the same question: is what I'm getting from the company either income or capital? I can't comment authoritatively on Scots trust law, although I suspect it might be similar or the same. But of course, all of the authorities that we're looking at are dealing with English or comparable Commonwealth law companies which operated the maintenance of capital principle, and that's the basis upon which these authorities have been dealt with. What's clear is that the trust examination depends on the terms of the trust and the settlor's intentions. And in my experience, settlors don't normally talk about in terms of dividends of a capital nature, but I suppose there's no reason why a trust deed shouldn't talk in those terms. But why should tax, a creation of statute applicable to the UK as a whole and its various systems of law, follow trusts in this instance? Trust law and tax law are not the same, as both Bates and Hill indicate that a dividend of share premium for a UK company, when it could be made, was treated as income for the trust but not taxed because it was regarded as capital for the tax system in those particular cases. And share premium is an obvious example where trusts and tax have always parted company at a time when share premium could be paid as a dividend. Duff's settlements, that's Lord Justice Jenkins saying that effectively the share premium was attached to the shares and effectively part of those shares, ensured that what was always treated as capital for tax purposes remained capital for trust purposes. Trust followed tax in that instance rather than tax following trusts. And there are other instances where tax and trusts part company. Scrip and enhanced scrip dividends would be another example. So Sinclair and Lee, upon which the Upper Tribunal relied for sort of having reached the conclusion, well, it doesn't look as if there's anything that's really a dividend of a capital nature, they said, oh, well, one must have to look and take Sinclair and Lee as an answer of something that is a dividend of a capital nature. As a general observation, direct and indirect demergers are now legislatively covered in the case of trusts by the Trusts Capital and Income Act 2013. But just because Sinclair and Lee concluded that the indirect demerger of ICI should be treated as giving rise to capital for the trust beneficiaries for the trusts in question and not income, does not prove that demergers are the only examples of transactions that give rise to dividends of a capital nature. The relevant question, the relevant principle to apply is how is this payment treated under the company law of the system applicable to the company making the payment? Is it part of the company's capital that it's returning to shareholders, or is it something, as in First Nationwide, a purely distributable element of profit, because Cayman, in its company law system, had not attached the premium in any way to its capital. The only way it could be returned was as a dividend, whereas, of course, in our case in Jersey, this was capital if it came out on a redemption or repurchase, capital if it came out under Part 12, but somehow not capital, even though it had exactly the same effect on the share premium account, capital account of the company, if it came out, was authorised to be made under Article 115 and Part 17. But that, I say, is no more than what Jersey law authorises under its company law by way of a reduction of capital. So, my lord, if I can, I'll try not to take more than, I'll say 30 minutes just in case tomorrow morning, if I deal with those points on the facts that have been raised where my learned friend would like to hear my submissions.
Yes, well, I think 30 minutes is probably the outer end,
Yes, yes.
but you'll take such part of it as you feel you need.
Yes, I won't have dealt with the Lonmin distribution, but that actually is relatively straightforward. I just need to point you to the facts of the Lonmin distribution, and then broadly speaking, what I've already said will apply for your consideration as to whether it's a dividend, and if so, whether it's a
Well,
capital.
Mr. Yates will be on his feet at 11 o'clock, even if you still are as well.
I will sit down at that point, my lord.
Very brief,
Have a very
brief, my lord. As my lady Justice Falk has asked, we've got the explanatory notes or the annex which list the changes, or rather the absence of a change.
good.
I don't know
Well,
if
if you'd be
you
good enough to
will
provide
hand it
Mr.
on
Gammy with one, then be passed in to us as well. Thank you very much indeed. Have a good evening.
Authorised Fable.